I'm Jim Fausone here at the Fausone Brandon law firm in Western Wayne County. I wanted to talk to you today about covenant not to compete, because we've seen a lot of changes over the years, and I have with me business lawyer Brandon Grysko, one of the lawyers here at the firm, and I'm going to pitch him a question in a minute and see how well he does answering it. But over the 40 years that I've been advising businesses, we've seen covenant not to compete be restricted and then allowed and then broadly used, and we're in the broadly used phase now. And those covenants help businesses make sure that their employees don't take business opportunities away from them. And courts in Michigan will allow covenant not to compete if they're reasonable. They have to be reasonable both in time and geographic location. But as I said, over the years, that's really kind of changed. Courts have taken different views on allowing and how they should enforce covenant not to compete. And one of the interesting things is the time we're in. And Brandon, that's my question to you. What have the courts been doing since we're in a COVID pandemic with furloughs and layoffs and unemployment? How's that impacted how the courts look at covenant not to compete?
Thanks, Jim. It has been an interesting situation, and certainly in COVID-19 times, we've seen a lot of things being treated differently, both by the courts and by businesses. But although courts are still willing to enforce a non-compete agreement, they are going to take a stricter and a closer look at the terms of that agreement to see how reasonable it is and to determine whether or not that's something they're going to enforce prior to a full hearing on the matter, or maybe not until after it's gone to trial. Well,
one of the things that you find when you look at these is sometimes the facts really change how reasonable it is to enforce a covenant not to compete. And I think a case in Pennsylvania certainly currently put that into a spotlight. Maybe you can talk about that.
Well, Jim, the facts make all the difference in cases like that. And I think the Pennsylvania case you're referencing, there's a 31-year employee with a sports retailer who, due to COVID-19 times and the turn down in the economic times and things of that nature, was furloughed by his employer. And then subsequently, even though he didn't necessarily have a job lined up, they still tried to enforce the covenant not to compete to keep him from finding new employment.
Well, as I say, the facts do matter in these covenant not to compete cases. And what advice would you have for a business owner who has a covenant not to compete that maybe was signed years ago and they threw in the drawer and they haven't thought about since, but these times make them think about it?
This isn't surprising. We see this a lot where, we as attorneys maybe draft a document for a client, but it is up to the client occasionally to dust those documents off and make sure that they still make sense for both the business purposes and for the changing times.
So we would encourage business owners out there, or employees if you have old agreements hanging around, to think about those, certainly at a time of COVID, a time of layoffs, and increased pressure on small businesses because of revenue and cash flow issues, to come back to your business lawyer, talk to them about what's reasonable under the circumstances. And we here at Fausone Bohn are ready to help you in those areas if you need some assistance. Thanks for watching.
Fausone Bohn, LLP is your premier full-service law firm based out of Western Wayne County, Michigan. If you have questions, reach out to us at 248-380-0000 or check out our website at fb-firm.com and connect with us on social media on Facebook, Twitter, LinkedIn, and YouTube.